I would like to introduce our interim dean and longtime, Washburn Law professor, interim dean Jeffrey Jackson, and I'll hand it over to you for your welcome. Thank you.
Thank you, Shawn, and good morning, everybody. On behalf of Washburn University and the Washburn University School of Law, the Law Journal, and the Dole Center for Law and Government, I'd like to welcome you to the Law Journal Symposium, Law in the Zoom Era, the Future of Virtual Lawyering. This is part of our annual Law Journal Symposium series that highlights important topics in the law for today. And as I said, this topic today is incredibly important, especially given the fact that all of a sudden we're all on Zoom again. So to all of the speakers and all of the participants, we're glad you're here today. Without further ado, I'm going to hand it over to Editor-in-Chief Marisa No to kick off the festivities, but welcome everyone.
Thank you, Dean Jackson, and thank you everyone for being here today. And thank you to our speakers for joining us for this event. My name is Marisa No, and I'm the editor-in-chief of the Washburn Law Journal for volume 62. We were all there to experience the impacts of COVID-19 in 2020. And as we're here today, we all continue to feel those lasting effects. For better or worse, the way we live may be forever changed, and so too may the way that we interact with clients in the courts. So today we've brought together some of the great minds and scholars at the forefront of this brave new legal world that we're encountering to speak on what's changed, what's working, what's not, and what's likely to happen from here on out. I'm so excited to hear from them, and I know that you all are as well. So with that, I will turn things over to Professor Ewert to officially get things started.
Thank you. So good morning, everyone. My name is Michelle Ewert. I teach in the Washburn Law Clinic, and I'm so excited to be spending the morning with you. We have several really exciting speakers here. The first is Brittany, Professor Brittany Stringfellow Otey, who started her career working as a district attorney and a private practitioner before going to teach at the Pepperdine School of Law. Professor Stringfellow Otey directs the Legal Aid Clinic, where she and her students represent low-income individuals who are struggling with homelessness and poverty in a wide range of civil cases. So welcome, Professor Stringfellow Otey. Next, we have Professor Isaac Mamaysky, who's a partner at the Potomac Law Group in New York. Professor Mamaysky represents multinational corporations, educational institutions, nonprofits, and various privately held companies in a range of issues, including employment law, HR, and then compliance matters. And he now teaches at the Albany Law School. And last, we have Professor Ray Brescia, who worked in direct legal services for a period of time, was the associate director of the Urban Justice Center in New York, where he represented community-based organizations around civil rights and economic justice issues, and now also teaches at Albany Law School. So Albany is well represented this morning. So we're going to have about an hour and a half together. We're going to start with each of our panelists talking to us for about 15 to 20 minutes about different aspects of this transition to more remote-based practice and increasing the use of technology in our profession. Then we'll have a facilitated discussion that I will lead with some questions for all the panelists, and then at the end, we'll open up to questions from the audience. We're going to ask that you hold any questions you have until the end so the speakers can get through their planned remarks, but we'll leave plenty of time for questions from you all. So we're going to go ahead and start with Professor Mamaysky, who's going to talk to us about career satisfaction that can be gleaned from a remote practice. Thank you so much.
All right, thank you so much. It's an honor to be here, a privilege to join the symposium. I should tell you, I'm especially happy that it's on Zoom because to my surprise, I tested positive for COVID a couple days ago, so I feel fine. But for all of your benefit, I think it's good that we're online. So in some ways, the pandemic has been a silver lining for the legal profession and for every practicing attorney. This is a topic that I explored in a paper that I just finished called Happiness in the Law, Lifelong Learning as a Path to Meaning and Purpose. We are going to talk about that momentarily. I don't think I can message the whole group. If I could, I'd put a link to the paper in the chat, but maybe if someone on the back end can work their magic, I can send around that link. But before we look forward, I want us to look backwards. And specifically, I want to take you back to March of 2017. Now, does anybody remember March of 2017? Really, the key thing to remember is that we were blissfully ignorant of what was to come a few years later in March of 2020, which is when COVID began. So in March of 2017, this professor of political science named Robert Kelly was being interviewed on the BBC from his home office in South Korea. This was a live interview, by the way, and I suspect many of you have seen this interview. So about a minute into the interview, his 4-year-old daughter prances into the room, like in the most literal sense of the word prances. She dances her way in. And a couple seconds later, her little brother comes in one of those baby walker things. And, this is again on a live interview. And then shortly afterwards, the professor's horrified spouse, like quite literally dives into the room, extracts the children, and the interview goes on. Now, that BBC interview went viral, like super duper viral, tens of millions of views on YouTube. What I find most interesting about the story is that today, it feels just like another day at the office. Every time I am on a Zoom call, every time I present like this, to a Zoom audience, part of me can't help but glance at my office door, which is that way, to make sure I locked it. Because if I didn't, my toddlers love to just come into my office screaming, "We busted down Daddy's door." I venture to say that anybody who's been working remotely or studying remotely has either personally had that experience or watched somebody else have that experience on the other end of the Zoom call. So now that we're coming out of the pandemic, that's a controversial line, by the way. I guess it depends who you ask if we're coming out or not. But many, many people, including President Biden, argue that we are coming out of the pandemic or we have come out. Now that we're coming out of it, a whole lot has been written about the remote workplace of the future. Experts argue that the pandemic has fast-forwarded us by decades in the direction of working from home. Surveys of business leaders suggest that in many industries and many companies, remote work is here to stay. So to explore the implications of this, we have what I think is a rare opportunity to use law firms, which are so often mocked as dinosaurs. But I think we have a rare opportunity to use law firms really as a model of innovation and as a glimpse into our post-pandemic future. So with that goal in mind, I hope you'll allow me to share a brief personal experience to sort of illustrate this larger point. So I started my legal career in the Manhattan office of a large international firm that was founded in the 1800s. As a new associate, they assigned me to the defense team for this public company, and it was a multi-party, multi-district commercial litigation. So in other words, I personally did a lot of document review for a multi-party, multi-district commercial litigation. The other members of my team were situated across the country. This meant that I would come into the office, sit down at my desk, and I would proceed to have phone calls, email exchanges, and chat messages with paralegals and attorneys who I had never met in person. We had Skype back then, but literally nobody used it for work. So I had never even seen these people. So although my supervisor sat in DC, we worked with a paralegal team in California. I was in New York, by the way, and the other attorneys were in offices across the country. It would have been out of the question, categorically out of the question, to suggest that any of us should work from home. A little over a decade later, following that first experience in remote work, I joined a law firm in which nearly 150 attorneys work from home offices across the country. That was a very intentional decision. These are the so-called new model law firms, and you might recognize some of their names. Culhane Meadows, Fisher Broyles, Ramon, Taylor English, and my very own Potomac Law Group. There are certainly many others as well. These firms have really been making waves in the legal industry because they figured something out. When you eliminate skyscrapers and expensive office space in Manhattan and Chicago and San Francisco and DC, and you have just a few flex offices available instead for when attorneys need them, then you massively reduce your overhead. That means the crushing billable hour requirements of traditional law firms simply go away for attorneys. It also means that clients pay lower rates for the very same attorneys they had at large firms. All of our attorneys came from large firms. So it's really a game changer for legal practice. And research of the legal industry has shown, and I find this really interesting, that large and mid-sized firms, sort of the traditional firms, they continue to see sort of incremental increases in revenue and headcount. By contrast, the new model law firms have seen soaring growth. That's soaring according to a Law 360 article that I just read about this. I start with these new model law firms because they teach us a few things about the state of the workplace coming out of the pandemic. Number one, they teach us that a number of industries have taken a deep dive into remote work well before our collective experience with COVID. Some of these industries have seen really positive employee outcomes and tremendous growth from that voluntary experiment. Number two, when a self-selecting group of employees choose to work from home, those employees tend to do very well in that environment. So lawyers, anecdotally, but research-based as well, but also anecdotally from my experience, lawyers at these new model firms are really happy, but it's also not for everyone. That's among the many reasons, by the way. Some people don't want to work from home, and that's great. And the traditional office is not going away anytime soon. But for those who do, for those who enjoy working from home, for those who seek out that style of work, there are tremendous new opportunities that we'll talk about. Lesson 3, when a particular employer has most employees work from home, its office expenses are substantially lower than the office expenses of competing employers operating in traditional offices. Both customers and employees benefit from those cost savings, and of course, so does the employer itself. All these things, to my mind, provide a glimpse into what we might call the post-pandemic workplace. And by the way, very interestingly, we're seeing a completely parallel trend in higher education, right? And specifically in legal education. A growing landscape of colleges, of graduate schools, of law schools are offering online education. And it's often asynchronous online education. What that means is that students can watch recorded classes. They can join online discussion forums rather than having to sit in a physical classroom at a set time. So now let's consider these parallel trends from a big picture standpoint, right? We are now living in a world in which employees who were once bound to jobs within commuting distance of their homes, these employees can now work from wherever they want for employers around the globe. Likewise, through online degree and certificate programs, students of any age can master new skills on their own schedule and without being geographically bound to their institution. To my mind, this is the silver lining of the pandemic. Before March of 2020, how many of us hadn't even heard of Zoom, right? The world has just fundamentally changed. Now, I told you that my article is about lifelong learning and finding meaning and purpose in the law. How do these things connect? So my article begins with the premise that the happiest and most fulfilled attorneys are those who live a life of meaning and purpose. The happiest and most fulfilled attorneys are those who live a life of meaning and purpose. To this end, I'd like to share a LinkedIn post that I recently read. It was written by a junior associate at Davis Polk named Travis Mitchell. I cited him in my paper. We've now become LinkedIn friends as a result, but I suggest you check out some of his content. It's very good. So anyway, here's what he wrote. Abridged version, to be fair to my friend Travis. He wrote the following. So this is a LinkedIn post. I'm quoting them. I found out at my review that I billed over 400 pro bono hours this year. Before going into, sorry, pause. Just for context, for those on the call who don't know, law students perhaps, Davis Polk is one of the biggest, most prestigious law firms in the country. So 400 pro bono hours at Davis Polk is like massive. I mean, that's massive billable time that the firm is losing. And that's tremendous resources of a very, very powerful firm being devoted to completely pro bono efforts. Okay, sorry, starting my quote again, that context was relevant. Okay, quoting Mr. Mitchell now. I found out at my review that I billed over 400 pro bono hours this year. Before going into big law, I promised myself that I wouldn't lose touch with the issues that I care deeply about. Many people told me that this wouldn't be possible as a corporate lawyer at a large firm. As a law student, I know that I was not the only one who experienced the angst of feeling torn between two seemingly disparate paths. However, as is often the case, this was a false choice of my own making. He continues, you should never sacrifice your values for a job, and you can always find a way to combine your professional and personal goals. End quote. His post quickly accumulated thousands of likes, dozens upon dozens of comments. The post clearly struck a chord. Multiple law students wrote that they were relieved. They were relieved to learn that they didn't have to sacrifice their values for their careers. Shouldn't this be obvious, by the way? Shouldn't it be our job as teachers in law schools to make sure students know this, that they don't need to sacrifice their values for their careers? Having now practiced for 15 years, I can tell you from personal experience, it's always possible to merge personal and professional goals. This is a foundational premise of my article. The idea is not a new one, by the way. It plays out across geographies and across cultures. Immediately upon reading what Mr. Mitchell wrote, it reminded me of a quote that's commonly attributed to another lawyer, Mahatma Gandhi, who said that happiness is when what you think, what you say, and what you do are in harmony. Much more recently, researchers in the field of positive psychology have found that meaning and purpose are key ingredients to living a happy life. And we delve into some of this research in my paper. So now we come back to the modern practice of law. We come back to our post-pandemic workplace to today. While many in the legal profession have found a sense of meaning and purpose in their careers, many others are deeply unsatisfied with their career trajectories, but they feel for a variety of reasons that they aren't empowered to make a change. I don't want to pick on any litigators. As a side note, I think litigators have a uniquely stressful job in the world of law. Perhaps in our discussion, some participants on this call can ask questions about why I feel this way, but not to pick on any litigators, but I started my career in litigation. I was recently speaking to an attorney, a friend of mine, who told me that she hates litigation. Her exact words, I hate litigation, but I've been doing it now for more than a decade. She said, people just see me as a litigator. How can I switch now? Literally word for word, our conversation. Now, unfortunately, study after study points to attorneys who are stressed and unhappy with their professional lives and would even leave the law entirely if they could. My article argues that these attorneys have a far more dynamic set of options than simply leaving the profession or staying unhappy. As our LinkedIn poster said, it's a false choice of our own making. I argue that it's not just possible, but indeed it should be the goal to merge personal and professional interests to find a career that speaks to your sense of meaning and passion. This is where lifelong learning comes in. As every law professor knows, as every practitioner knows, and as law students are quickly learning, law school taught us an analytical framework, right? How to think like a lawyer. This is reinforced in all aspects of legal practice. Relying on those analytical skills, it's entirely possible to evolve professionally, learn new practice areas, write on new topics, and continually pivot in one's legal career to make sure that our career aligns with our sense of meaning and purpose and our personal goals. And by the way, I say continuously pivot because it's important to understand that meaning and purpose change over time. So even the most fulfilled attorneys need to continually evolve to hit the mark. What may have started as a really, really meaningful career because it aligned with one's goals and values when they were 25, that same path might become far less meaningful 15 years later, or 20 years later, or 5 years later. That's when it's time to pivot. It doesn't have to be an immediate pivot, and it doesn't have to involve some huge professional risk. Now, this might come as a great surprise to law students, but when practitioners work to understand a new area of law, we don't sit down with a dense casebook and then attempt to answer the hypothetical questions following the cases, right? Rather, we pick up a practitioner's guide to that area and we read the relevant chapters. It's amazing what an attorney can learn in 7 pages a day. If you read 7 pages a day for 2 months, you would have read a 400-page treatise on some area of law. If you then start writing some articles in that area, exploring interesting questions that you learned in the treatise, you present a couple CLEs, you speak at a couple relevant conferences, what happens over time? Suddenly you become the expert in a brand new area, and it just starts with 7 pages a day, and then you legitimately become that expert. And by the way, you would be amazed how much you can write if you just write 1 page a day. Write a page a day for 2 months, and you're going to have a 60-page article that you can then pitch to law journals, and then go through the very pleasant process of having it rejected by most, but accepted by one, which is really all you need. But that's a topic for another time. The point is that these small steps will lead to major knowledge gains, and they establish expertise over time. It leads to a gradual pivot in which you can ensure that your career and your expertise stay fully aligned with your values and your sense of purpose. And keep in mind, online asynchronous education has opened up new worlds. You can literally get a graduate degree in whatever topic you want from the comfort of your home and on your own schedule. Granted, you don't need a graduate degree. You don't need any degree beyond your JD to pivot in your career, right? I only mention this to say that the possibilities are endless, right? You have so many options in our new world. The final thing to keep in mind is that outside of our ethical duties, right, there are no rules in the professional world. Nowhere does it say that a litigator can't switch practice areas. Now, of course, that's not to say it's easy, right? But nothing of value is easy. What I always advise law students and attorneys who are unhappy with their paths is you just have to kind of, for lack of a better way to put it, you just have to stay hungry, right? You have to be prepared for failure. You have to be prepared for rejection, because nothing good happens without it. And the analogy I already hinted at, which I'm sure law professors can appreciate, it's a bit like submitting journal articles, right? We write something we care deeply about. We hope it's original, we hope it's insightful, and then we pitch it to our law student friends at all different journals. And how many rejections do we get for each acceptance, right? But we press on, that's the process. And so it goes with making pivots in our legal career. It's not easy, right? But we press on, and that's how we maintain a sense of meaning and purpose. You know, there's this fairy tale quote that appears on mugs and t-shirts. It goes something like this: find the job you love and you'll never work a day in your life. I think it's absolute nonsense, by the way, but if you believe it, your career will be much worse for it. I think the far more accurate statement is, if you find a job with meaning, then you can overcome all the hard work and sacrifice it requires because you are living with a sense of purpose and passion, right? To my mind, that is the goal, and that is the recipe for career happiness. Extensive research tells us that we need to pursue meaning and purpose to live a happy life. Through lifelong learning, we can ensure that our career constantly evolves as meaning and purpose evolve in our lives. And we now have the benefit of a tectonic shift in the very landscape of both employment and education. We can learn from anywhere. We can seamlessly work for an employer or for a client across the globe. We're no longer bound by geographic constraints, and it opens up new worlds. If law students take this to heart, I think it will lead to a more fulfilled legal profession. So that's all I got. Thank you, everyone, for your attention.
Excellent. Thank you. We're going to come back to some of these issues, but next we're going to hear from Professor Stringfellow Otey, who's going to talk to us about the rollout of technology in the courts during the pandemic and what this means for access to justice for low-income litigants and some of the perhaps more negative impacts on attorneys. So thank you, Professor Stringfellow Otey.
My pleasure. I think I'm sharing my screen. I'm so glad we started with an optimistic and positive start. So thank you so much, Professor Mamaysky. I'm inspired, and I might change careers. I don't know, but I'm going to do it. Just kidding. My context is a little bit different, and so probably it's good to set that just before my comments. I direct the Pepperdine Legal Aid Clinic at Union Rescue Mission, which is in downtown Los Angeles. We unfortunately are the largest and most embarrassing treatment of people who are unhoused in America. There's about 40,000 people in LA and 60,000 in the county, and then thousands living outside of several shelters in the Skid Row area, which is about 49 square blocks in downtown LA. In the 70s and 80s, they chose a containment theory, which was move all the services and all the people that we don't want to see into one small area, and I'm sure it'll be fine. And in 2022, we are definitely dealing with the fact that it is not fine. So we are located in the Union Rescue Mission. We partnered with them in 1998. And then in 2016, we also partnered with Covenant House, California, which provides emergency shelter for youth, a lot of kids coming out of the foster care system. So that's in Hollywood. And so those are the two sites, primary sites. I should say Union Rescue Mission has opened 2 other sites since we began. So we're altogether the 4 different sites. We 2020, the question for us in 2020 became, how do we do community lawyering when we can't be in the community? Part of the signature of our programming has been that Pepperdine is in Malibu. Maybe you know, it's a wealthy enclave north of Los Angeles. And there were some students in a class in 1997 that said, hey, we say we have this purpose of, service and leadership mission at Pepperdine. Who are we helping? What's going on? And that led us to partner with the Union Rescue Mission. But so part of that relationship has been about proximity. It's been about being on the ground and being alongside our neighbor. And so suddenly in 2020, that really important piece of how we've served and how we've partnered with that community was taken away. We went on spring break in March 6th, and by March 16th, we obviously couldn't come back into the building. And the area around in Skid Row was hit very hard. Our shelter in particular, when we decided not to return to the building, had 100 cases by March 16th, and we had several deaths. And so it was a very intense experience with COVID. In fact, it's so strange now that I've had COVID while traveling, and it's like, it's so inoculated now. My experience has been that it's inoculated. It feels less so now. And I have a hard time connecting that with how intense those first months were, with so much loss and so much fear on Skid Row. And then a lot of places got to go back, throughout the year, or do trials going back into their offices and things. But we've had several outbreaks at our shelter and in the surrounding areas. And so honestly, we have had lots of starts and stops, and we're pretty much out of our office for 2 years. So it's a very strange and confusing feeling to be running a Skid Row law clinic from your bedroom in a suburb, of Long Beach. So that's kind of the context that we've been trying to figure it out in. So I do want to say some positive things about technology. And I also I have a bias. I like being with people. I'm sad that I'm not in the halls talking about this stuff with you after in between the conference presentations. I was excited to meet you, Marisa, and all the faculty. So that's my bias. I'm appreciative of what technology has afforded us, and I want to acknowledge it, but we're going to get into some hard parts. So I can't believe how things rolled out. I can't believe how quickly I was able to access documents and records online that I've never had access to. It really was amazing, and kind of on the same but different turn. We housed people very quickly during the quarantine era, and it's because we were afraid, but we were able to do things that I didn't know that we'd be able to do. So you can see across the country, there's an unparalleled rollout. I hope you appreciate that I didn't say unprecedented. In the Texas court system before the pandemic, there were no remote civil hearings, and there were 1 million between March and February of 21. Amazing. In evictions in 2019, no state had any kind of virtual hearing culture. And by November of 2020, 82% of state courts had permitted the remote hearings and 15% required them. So being able to just turn on a dime like that especially when you think of an archaic system like our legal system, it really was pretty amazing. Same with e-filings, we increased from 37 states providing them to 47. So really impressive. There's no way we would have been able to run our clinic and continue services to people that we really wanted to serve without technology. We were able to have, like I said, the increased online access to court filings and files and e-filings. We suddenly were running a virtual clinic from a series of bedrooms all across the county. You know, it's like students were in their cars sometimes, and they were in their bedrooms and at the beach occasionally, I suppose, but we're able to provide services with a very small gap. I really am amazed by the ability that we were able to, as soon as we found our clients again, because we had about a month where we did have a hard time getting a hold of people. And then we were able to app-based communication with our clients to keep our anonymity as far as for the students, but also being able to access people. So I'm totally amazed at how quickly things rolled out and how smooth that was. But technology sort of exposed some things to me as well. So one of the big things was access. So we talk about access to justice, and though technology was intended to increase access to justice, we just missed, there's just some things that we've got to grow in if we're going to use technology. A lot of my clients have smartphones. It's passed out. A lot of our clients get them through the Affordable Care Act, which makes reaching them so much easier, and I'm so grateful. But 40% of low-income families don't have access to a computer. 52% of Californians have broadband with more than a minimal connection speed. So making those hearings, court hearings, is very difficult. And when you look at rural areas, pretty extensive, 20% lack access to any broadband as well. And then there's just the understanding. And this is what I experience a lot with my clients. Like, yeah, it's great that I can call into my hearing. And in some ways, there's a beauty to not having to take a whole day off of work to attend a court hearing. So there's something really promising about that. But unrepresented litigants have a difficult time navigating the legal system. And I know that's no surprise to you in law school, because it's difficult as a law student to understand the legal system. So even without education, it would be even more difficult. So 79% reported trying to use websites to research their rights, but 40% were like, I don't even know what I'm looking at or what I'm looking for. 75% of unrepresented litigants need help completing court forms. And then when you think also about generationally, older adults have limited access to internet-based services because of low socioeconomic status, internet skills, and also just acceptance of technology. So it's available, but it's not available to all. In many ways, it made it more burdensome for the unrepresented. There's an expectation of utilizing the court, but not being able to come inside. That was a difficult part of 2020. And then the Pew Charitable Trust did a report just reviewing 2020 and the access to justice. And they realized that of nearly 10,000 state and local pandemic-related orders reviewed for the study, none specifically addressed technology accommodations for people with disabilities or those with limited English proficiency. If you serve these populations, this is not surprising, but it is kind of depressing. So it's like we always sort of miss the mark in serving these folks. So a couple of questions come to mind when I'm assessing how we're using technology to serve, particularly the unrepresented. And so one is just, does it provide access to justice? And I have questions about that. The other question I have is just, does virtual connection result in a quality connection? So I think of that in terms of like building empathy and rapport. Now it's tricky for us because we couldn't actually use Zoom with our clients. We learned pretty early on that that broke a barrier with our clients that we maybe didn't want to be a part of. So we saw a little too much early on. So we went to phones, worked pretty well. But what you do find, even in just teaching for 2 years online, is just it's hard to sometimes make a connection across, particularly when you're building a new relationship. So we found with our clinic, a lot of times we try to do as much, going forward, we're trying to do as much initial visits in person and then utilize the technology to sort of bolster that going forward. But building that first connection, most studies say that people do prefer like a first impression, prefer a in-person meeting. The other piece that I think about when it comes to whether we have a quality connection is just interruptions. I'm sure at the very big, well, I don't know, at our school, we had some Zoom bombing at the beginning before we all learned to have passwords. And, but I'm sure you've dropped calls, buffering, lots of background noise. My husband now works from home, and I do appreciate Professor Mamaysky that, you know, there's a norm to just having a little bit of a more loose, like, you know, if the kids come in, it's not that big a deal. But I think about our dog just interrupting so many of my husband's meetings while he, you know, we just can't train him to be quiet. Anyway, so just the interruptions of the connection is just something to take into consideration. And then I know that Professor Brescia will touch on these probably as he talks about ethics, but the other piece that comes up with the quality of the connection is just our duties of competence and confidentiality. The model rules set out that we're supposed to stay on top of technology and the changes and understand the benefits and risks of things that we're using. It's been a little bit of a wild, wild west the last few years trying to implement things quickly. But as a professor, I'm always trying to get us to think about, yeah, we can, but should we? You know, is this something that we should be implementing? And so trying to think that through. And California's formal opinion reminds us to think about confidentiality, technology competence, communication, and supervision. And I think each generation of lawyers has got some challenges in those areas, whether it's being too reticent to adopt technology or perhaps jumping in a little bit too quickly. So things to think about. It's very interesting. The 2020 survey that came from the ABA said that a number of firms had experienced a security breach, like lost or stolen computers, hacking, breaking in, website exploit over the prior year. And it had gone up since 2019, which makes sense because we were probably using a whole lot more technology than we had been in 2019. But the interesting part to me is that the survey results say that despite the ethical challenges and the issues, the survey results revealed that use of certain security tools were still remaining at less than half of respondents. And this is true, just to my anecdotal understanding, is that we sort of have a sense that we have a duty, especially in like private or smaller firms or whatever, but maybe not having the rollout of the protections that we might want to be putting into place and have a duty to be putting into place. So the quality of that connection, I think, is something we need to keep an eye on. The third thing I just want us to think about today is, does remote work result in an increased quality of life? And the first presentation definitely showed that it can, and it has a lot of potential. There's a shadow side to working from home that we're all sort of also trying to figure out. And that is that remote work often leads to overwork. And there are articles where people talk about, I had so much flexibility, which I really loved, but then it was hard to disconnect. And it's hard to have a separate space. I live in Los Angeles, where we just don't have big houses. And so your space is, you know, where you also eat or where you also sleep or whatever. And so working from home has some complications. And then also just the proclivity to work through sickness. You know, I'm guilty. I was like, I have COVID, but it's fine. I'm fine. I'm not going to get you sick. So I can do this, which I think when we talk about well-being is maybe something we should think about. And then it just also results in longer work days. And so there's a Microsoft study that came out last year that workdays were up 10% from 2019 to 2020. Respondents talked about they had fewer phone calls and more emails. And I know that it sounds good to not be stuck on the phone all day, but I think that there is probably a consensus too that there's an amount of emails that is just too much. And so just thinking through like what effect that has. And in this study, they found that it just sort of has a silo effect, that you're just in your own little space and human connection, and you have to be pretty intentional about making that. What we know about overwork is that it has more side effects and detrimental results than we think about. Overwork is defined as working more than 55 hours a week, and I don't think that's too uncommon in our profession. The World Health Organization says it's the single most significant risk factor for occupational disease. Overwork led to 745,000 deaths in 2016. It increases significantly our risk of stroke and heart disease. And it just has ripple effects. We just don't feel great. We don't sleep well. We don't exercise because we didn't have time. We eat poorly because that's what's quick and easy. The stress leads to smoking and excessive drinking. So it's a lifestyle that I don't think we set out to want, but it's definitely a side effect of overwork. And let's be honest, stress is part of our context. It's part of our reality. I tell my students, I think you can change this, but you've got to know that you're going to have to swim upstream to have a different kind of life because our numbers are not great. We lead other professions in all the things you don't want, suicides, drinking, depression, unhappiness. It's a reality. And my heart and my study as a professor is I just want people to have a life that they want because they sure have sacrificed to get this. And so we have to be honest about what we've got. And so there's that 2016 Betty Ford Foundation study that talks about problem drinking and depression, anxiety, and stress, and really keying in on your first 10 years of career and those working in large firms. So I don't say that to depress people. I do feel like my presentation is a little sad, but it's that you just have to know what you're up against so that you can be strategic. I'm glad that they did a more recent study because I got kind of tired of quoting such an old one, although the results are not great. There's one that just came out in 21, Stress, Drink, Leave. It's an examination of gender-specific risk factors and mental health problems and attrition among licensed attorneys. They found that over 50% of attorneys screened positive for risky drinking and 30% for high-risk hazardous drinking. So we're still coping. And to be fair, this also included the pandemic. So I think if people were coping, even people who didn't drink, I think started drinking in the pandemic. So I do think that maybe this might even out just a tad. But the reality is we've been in a rough spot. And if we're not intentional about getting out of it, I don't know that it will just naturally get better. On mental health, you see a lot of depression. You see a lot of anxiety. And then the part that I think is quite difficult about this particular study is that women are experiencing meaningfully worse mental health than men. I do think that's a pandemic, and that's probably inspired by the pandemic, just because a lot of balance issues really were highlighted during the pandemic. But you see that 25% and still 17% of men are contemplating leaving the profession because of mental health, burnout, and stress. So I'm always like, and Debbie Downer, I'm so sorry. So I want to talk about some of those stressors, and then I want us to talk about what are some ways forward. I am going to end on a happy note, I promise. But I don't think that we can just ignore those stats because I think that's where we get trapped. So one of the things I've been thinking a lot about is when we're talking about stress and well-being is how is the technology contributing to this? And I found a great article, actually techno-stress, the phrase comes from an article in 1984. I mean, people have been talking about what will these machines do to us? And I guess we just thought, oh, well, it's going to lead to a 4-day work week. So we'll be fine. And that hasn't happened. But what I do with my students is we talk about these different types of kinds of stress that come from technology and just try to figure out what do you resonate with. So techno overload is just the amount of interruptions, multitasking, prolonged work time, expectations on how quickly you're supposed to respond by email. That's that stress that comes from your technology. And it seems like the smaller the technology gets, the more quickly I'm supposed to respond to it. So ask me why I'm wearing an Apple Watch. I don't know. I've submitted, I guess. Techno complexity. So just being introduced to some technologies are particularly complex. And when I think about being in a supervisory role and having to explain or plan out how it will be rolled out in my department, that complexity comes up. This is also the techno complexity can also sort of show itself in generations. So maybe if your generation's not as familiar with the technology, that complexity can create a stress in you. Techno invasion. This is the blurred boundaries between work and your other life. This is important for everyone to consider, but I think especially if you work in a high need environment where your work, it makes you susceptible to secondary trauma. I have to be very careful because of the kinds of cases that I handle to not let my work invade my time on the soccer field with watching my kids play or something. I learned really early on that invasion and that blurred boundary can really take away from my satisfaction in my home life. So paying attention to that. Couple more. Techno unreliability. I'm sure none of us have been let down by technology. Technical errors, difficult usability. I can't imagine that I'm the only one that had a bit of a nightmare last night about not being able to get on when I was supposed to. And you think about it, you used to just make a presentation, and then now we've got an extra level of like, will the technology support me? And so there's a little low level anxiety that comes from that. And then finally, I think we saw this a lot when we started to do work from home, but just people feeling surveilled by their technology. So paying attention to how much time you spend on your computer. We've had lots of conversations about what's the best way to supervise people working from home. And got to think about the stress that comes from that surveillance and lack of autonomy. So those types of stresses are all kind of leading into the general work-life balance. So let's talk about a few ways to move forward. I want to think about like quality of access to justice. I don't have all the answers in this. I know that if we're going to continue to use technology, and it's here to stay, so let's do it well. I think about how can we reach the unrepresented litigant? How can we make this not more burdensome to them? And like I said, I do love that certain things are available. And I really love the idea of them not having to give up a full day of work in order to attend a hearing. To me, that's a real motivator for me. So there was a work group on homelessness for the Chief Justice in California, and lots of good ideas of like, we've rolled this out quickly, but how can we do some things differently in the future? And one idea is mobile courts. So bringing technology to folks who don't have that access. I love that in LA County, they, using the courthouse library or the attorney's offices, although for a long time we couldn't get into our offices, but mobile courts in a truck, bus, and van. I love the ingenuity. I love that it's not just the legal aid lawyers figuring this out. I love that the court was involved in that as well. Another article by one of the authors is my friend Luz Herrera, who does great work with unrepresented folks, just thinking through and taking on the perspective of folks who are unrepresented or having financial restrictions. We had to rethink the way that we do everything. I would love to just send and email my documents to the client, have them send it, have them fax it back or whatever. And just recently I saw someone at a UPS store. I was returning Amazon stuff, but they were spending $12 to send a fax to DPSS. I thought we've got to be careful about how technology costs for folks. And so paying attention to how best to use technology and not to make it cost burdensome for clients. But then also just thinking about what kinds of networks already exist in the community. So thinking about that courthouse library or vans and trucks bringing the technology, but also most clients do have a smartphone. So what can we do on a smartphone as opposed to requiring a computer? So just thinking creatively about giving access. Whoops. The other thing that I think the Pew report really honed in on and is, I think, a bit shameful is that we didn't hit the mark on ADA accessibility. So making sure that our friends with disabilities are able to access the same justice. So there's great suggestions here about making sure that there's captioning and ability to magnify screen content, creating transcripts, describing all of your images and videos for folks who are visually impaired or blind, but also people who are calling in by phone, couldn't get the broadband that day. Just being so mindful of who's on the call and who needs access. And then also just avoiding flashing or strobing animations, which I don't know that we all have the broadband for that anyway. So it's best to leave that off probably. And then thinking of quality of connection, I'm going to leave the ethical questions to the next speaker. But when I think about just like empathy and rapport and building, the people that I've gone to for this kind of thinking is, telehealth was doing this before lawyers were. And so I often will look to like, what's medicine doing and what have they learned? And so lots of studies where nurses are trying to figure out how do we build this rapport so quickly over the phone or over a screen, especially when you think about how in telehealth, the rapport is so important to be able to get a good diagnosis. And so with that on the line, and I think probably the same amount is on the line for lawyers and for justice, just ideas of like keep, looking directly at the camera to create eye contact And really realizing that if we appear uncomfortable with the technology, and this is of course with the telehealth visit, but it kind of undermines the perception that we have overall competence and trust. And so I think that's something to really think about. That's going to keep me up at night, quite frankly, because I'm always afraid I'm going to drop a call. But just working to prepare ourselves so that the client can feel confident in many ways about how we're going to be able to help them. And then just using lots of mirroring language and repeating key phrases. That mute button sometimes it's helpful because you can't hear my dog barking or whatever, but it keeps us from connecting, I think, sometimes. So they talk about using verbal cues and not leaving a lot of quiet space, because this idea of a negativity bias where the client or the patient in their experience would assume that you're thinking something negative when you're quiet. And so just trying to really engage with clients, particularly if there's a power dynamic difference or any other kind of block like that. And then when I think about moving forward in quality of life, the thing I just have probably been, the flag I've been flying for the past 15 years probably is we just need boundaries. If we want to have balance in our life, it's going to require some boundaries. So one thing is thinking about those techno stress categories. And I've done this with my classes. Which ones do you resonate with? And what is your strategy for them? How are you going to minimize the leash that the technology puts on you? And how are you going to have boundaries between in real life and technology? Tech breaks. There's a great book called Tech Shabbat that really encourages a very analog response and a traditional, historical and religious response to technology, which is turn it off for 24 hours a week. And if you can't imagine that, try 4. It's like just ease yourself in to giving that breathing room and that I think that when we turn off our tech, we have some space for some creativity. And that all kind of comes back to social justice for me, because my clients need me to be creative and fresh and ready to go. And so whatever I need to do, if I can't do it for myself, then I can often make myself do it for them. And then thinking about written policies, having a communication amongst whoever you're working with. How are we going to establish when is a reasonable time for a meeting? With my husband working from home, we've had lots of conversations about what is a reasonable time, and how late should things go, and what are normal business hours. Those things have to all be renegotiated, restated in this new era. Encourage ourselves and each other to take vacation days. And another great suggestion was a quiet time policy, where just giving everybody a week where they don't have to answer email, which sounds so small, but probably pretty revolutionary for a lot of people. So just getting ourselves some boundary on that. Communicating our working hours and expectations with clients. We do this in our clinic. We have various modes of communication to keep everybody in the loop. And we have to say, this one's for the workday and this one's for at night. I don't want to text in the middle of the night from you about something that you just happen to be working at 3 a.m. I'm not. So trying to figure those types of things out. And I'm really finding that the more clear the communication and the more clear the expectation, the better. And then just scheduling breaks in the calendar. Actually calendaring your breaks is a good step. And then the main thing would be to actually take them. And so encouraging each other to separate ourselves from this technology that is so useful, but also, it uses us a bit. And so those are some thoughts that I've got about this. I think our clients are worth it. I think access to justice is worth it. And I think our lives are worth it. So thank you so much.
Thank you. So we're going to come back to some of these issues in our question and answer time, but I want to first give Professor Brescia a chance to talk a little bit to us about some of the ethical issues that this technology raises that Professor Stringfellow, Otey already touched on a little bit, but Professor Brescia is going to develop that a little more. So thank you, Professor Brescia.
Sure. Thank you, Professor Ewert, and thanks to everyone for having us here today, to Dean Jackson and Dean Leisinger, the journal team, my co-panelist and moderator. It's great to talk to you. And I have to say, I am certainly missing out on some great barbecue. I know by not being there, but it is a gorgeous fall day here in New York. We're the perfect time of the season. but it's interesting to sort of think about, how this time is different, or we're seeing things we've never seen before. In reality, the legal profession has changed dramatically over the years, often in response to changes in technology. The 20th century media theorist Marshall McLuhan said, he's the one who coined the phrase, medium is the message, but he also said, we are shaped by technology, but we also shape it. And in many respects, the legal profession, has been shaped by technology and has shaped it. So, for the first century or so of the American legal profession, following the Constitution, there were no law schools for all intents and purposes. You went to you apprenticed with a practicing lawyer. Almost exclusively, those lawyers were solo practitioners. They might, we might consider it, a WeWork space where they might share some space with other lawyers, but they were solo practitioners with these, some would have one or two apprentices or more. And those apprentices were basically carbon-based Xerox machines. That's what they did. Think of Bartleby the Scrivener. They would copy legal pleadings and contracts and wills and things like that. And that's what you did as an apprentice for 3 to 5 years before that lawyer agreed to let you sit for the bar exam, which was an interview with a sitting judge who would sort of say whether or not you had, earned your stripes. Well, all that would start to change in the late 19th century with the advent of simple things like the telephone, the typewriter, rapid reproduction of case law, and the ability to disseminate legislation, easily through rapid copying, and the old guard of the profession, these sort of solo practitioners who now might be practicing with one or two other lawyers at this point. They didn't like this. They didn't like the emergence of the modern law firm, which happened at this time. The use of telephones. The fact that a court would issue a decision and their adversary would have a copy of it in a couple of days. So, gone were the days when they could walk into court and start spouting general principles of common law and, kind of making it up as they were going along and hoping that the judge would agree with them. And their adversary would say, well, actually, the Court of Appeals just ruled this. And what are you talking about? And there'd be a decision. They were not used to this, and the telephone would destroy the trust that a lawyer formed with their clients by meeting with them face to face. Right? Sound familiar? And shocking of most of all was that now there would be secretaries in the offices to answer the phones and man the typewriters. And I say man, but these weren't men. This was perhaps most shocking of all, that there would now be women allowed into this very gendered space of the law firm. So, the old guard didn't like it, right? Fast forward, 80 or so years, when I started law school, we were just sort of starting to use things like Westlaw and Lexis. Well, we also used a service, and we were trained to use a service. And some folks who are, of my cohort might shudder when I say doing hard copy research on shepherds, right? Shepherdizing a case, okay? Now, if you've never done hard copy shepherdizing, let me tell you what it entails, okay? You go to the library, you pull out the corresponding shepherds to the reporter, the case from which, the case that holds the case you're trying to shepherdize, right? It's a verb, right? So you look at the shepherds, a nice bound, thick book, and you're like, oh, okay, there've been a couple of cases. Well, that's not good enough. Now you've got to go to the pocket part, which, might be there, might not be there. Then you've got to go to the slip pocket part, which is, which they generate, shepherds generate, every sort of month or so. You're looking at all of these subsequent publications for, until they get bound. And you're worried like, well, maybe someone else, maybe even my adversary has the critical pocket part that I need, and they've got it somewhere in the library, or God forbid, the librarian hasn't reshelved it, or maybe in the mailbox is the latest version of the shepherd's pocket part. And I'll never really know for sure whether I've accurately shepherdized this case. Well, now, what do? Right? You press the shepherd's button, which is spectacular, right? So, we've gone through dramatic changes in technology in how lawyers function, right? And, some people sort of sometimes say, is the law going through what the late Clayton Christensen said, the innovator's dilemma, where, disruptive technology is changing the practice of law. I think it's not disruptive technology that we're using today. It's what he would call sustaining technology, because we're just allowing the way that lawyers operate to just change somewhat, and to get better in a lot of ways. And let's move to sort of talk about remote technology as sort of I think the biggest change we've seen in the last few years. Now, it was interesting that my colleague, Professor Mamaysky, talked about, March of 2017. Well, in March of 2017, if you had done a survey of law firm partners, they would have said, work from home? Are you insane? We're never going to allow people to work from home. I remember as a clerk in the mid 90s, and my judge, old guard, lawyer, former practicing lawyer, my co-clerk and I used to strategize, how could we imagine getting, a 2-hour window where we could be home for the plumber to come to our apartment, right? It was almost impossible to get our judge to give us even the slightest, leeway on being in the office. Same thing with partners at law firms a few years ago. Well, a funny thing happened in March of 2020 when partners got to, decamp to Martha's Vineyard, and they said, oh, wait a minute, you mean remote work means I can work from Martha's Vineyard? I like this a lot, right? So apart from, just the public health protocols, we had to change, and we realized that the sky didn't fall, right? The sky did not fall. And, we can look at, remote practice, remote appearances, and see that there are a lot of benefits to it. And some of my co-panelists have gotten into them. I'll touch upon them briefly a little bit later, but I do want to focus on the ethics of all of this. And the ethics of it are relatively straightforward and quite manageable, right? There were some early opinions from the ABA, from different states, saying that you could work from Martha's Vineyard as a practicing lawyer in New York, provided that you did, if you weren't barred in Massachusetts, provided that you didn't, hold yourself out as a practicing lawyer in Massachusetts and provide legal services to people in Massachusetts. If you were working remotely in New York, providing, services in New York, that was fine. Very, very reasonable. Not, I don't think that there were, serious fears that this would be a problem. But, we had bar committees and the American Bar Association clarify that, yeah, this is okay. And I think that's totally appropriate. When it comes to, the sort of relationship between competence and supervision, the bar is quite low, right? It's, that we provide, Rule 1.1, that we have, that we provide services necessary for the representation. 1.1, 5.1, that supervisory lawyers have reasonable efforts are in place to ensure that the firm has in effect measures giving reasonable assurances that all lawyers in the firm conform to the rules of professional conduct. We are, at heart, a very reasonable profession, aren't we? 1.1 comment 8, that we should keep abreast of changes in the law, including the benefits and risks associated with relevant technology. 1.6, hold on a second, 1.6 comment 18, right? That we've got to have reasonable measures in place to ensure that we preserve confidentiality. So, that means, putting some of those things together when it deals with remote work, we have to make sure, we're not, if we have roommates, if we have, we're in an apartment with, thin walls, that people can't overhear our confidential communications with our clients. But, the bottom line is, I think, do we miss out a little bit? I think this is something, in terms of competence and mentorship, I certainly think we do miss out on the sort of experiences that new lawyers have, through, to a certain degree, sort of osmosis, being, in the room when your supervisor, the partner, the lead lawyer on the team is, negotiating with opposing counsel, with arguing before the court, on a scheduling matter or a discovery dispute, just being in the room, being able to pass notes, to sort of, learn that sort of thing. I was talking to a lawyer the other day on this point, and she said, she, might be, a sort of a trope to say, at the water cooler or in the kitchen, or at the coffee maker, and the lawyer walks by, or the senior partner walks by and just sort of talks about their weekend and says, oh, it was rough. I was, preparing my opening all weekend. And she said, mental note, okay, even the senior partner at the firm works on weekends practicing their openings. I need to know that that's what you do, even as a senior lawyer, even as someone with, decades of experience. Those sort of little things, I think we lose a little bit. But I also think we gain a lot by flexibility and remote work, particularly when it comes to, inclusion, right? Inclusion of people who cannot, be at an office 70 hours a week for whatever reason, for family commitments, because of a disability, a mobility impairment, because they work better, on, certain creative matters, away from the hubbub of an office. I certainly know that and experience that as an academic. I'm blessed with flexibility in my schedule. Not as a clinician. I know you don't have lots of flexibility in your work, but as a podium faculty, I do have a great deal of flexibility, for which I am grateful. I can't write in my office. I just can't. That's where I meet with students. It's where I might prep for class, but I am grateful that I have the flexibility in my schedule to be able to write and compose my scholarship and to research from home. And it might be, I'm very also blessed to have, a porch and a woods where I can walk my dog, and a little yard and a couple of places. If I want to set up on the dining room table today and in my office, which you see now, I can do that. I'm very fortunate to have all that. And I try to maximize the benefits of it. I think, for clients, I spent 15 years working in what I used to call the lowest court in the land, housing court in New York City. And one of my working poor clients would have to lose a day of work and, spend a morning in court, maybe for a 2-minute appearance before the judge. And now, they can join by phone. I think that's fantastic. Which represents real progress. I think that there certainly are issues of the digital divide that we have to overcome. I think, we have to be mindful of the limitations that our clients will face with this kind of appearance. There is a democratizing value to digital appearances. If you're reduced to a 1-inch square on a screen, you're the same size as your adversary, as your landlord, as the lawyer for the other side, as the judge. It can be empowering. It also, of course, can be disempowering if you can't access it, if you're calling from the library, if you're calling from the parking lot of the Walmart where there might be some Wi-Fi you can jump in on. So we have to be very mindful of that. I think that there's a great organization out there, the Asylum Seekers Assistance Project, and they've put out a best practices, because they formed in 2016 as a completely remote organization, and they have offices throughout the country, and so they've put out a memo on best practices in remote lawyering. And one of the things they talk about is using video whenever possible, whether it's communicating with clients if possible, communicating with coworkers, with courts, is that even if you can't be in the same place, the verbal cues you may not always pick up, and certainly the visual cues are much better communicated over video if that's the best that you can do. I think to go on, to jump off on something that others have said earlier, there is something that we can take away, I think, from all of this. And Dan Pink has a great book called Drive, and he gets into some of this, this idea of the people who enjoy their work the most have what he calls 3 nutrients: mastery, autonomy, and purpose. And I think that being able to master the really exciting creative elements of lawyering, having a degree of autonomy where you can be flexible, you can work from home or a place that's accommodating to you, having some control over your schedule, within reason, obviously, and with also being mindful of the need for mentorship. But also finding that purpose and finding what you love. I spoke to a former law school dean who then became a judge, and he said to me, and he's sort of in the end of his career, and he said to me recently, I've never worked a day in my life because of the jobs that he's held, law school professor, dean, and judge, and I sometimes feel that way. And maybe some of that is because I never worked in a big firm. I always worked at legal services offices, and then worked for a judge, and for the last 15 years have been teaching. And it's being a lawyer has been through all of that has been an amazing experience for me. And I being able to work with people and support their efforts to get greater justice. That has really been so rewarding and has given me some purpose. I think we all, as a profession, just to wrap up a little bit, in this moment, we have to really recommit to, and this is going to come out of left field because it hasn't been talked about yet. We really have to recommit to the rule of law and being able to work as lawyers in effective ways where we can exhibit mastery, autonomy, and purpose, and committing to the purpose that the profession should embrace, which is the rule of law, no matter what you're doing. And as a lawyer in legal services, I certainly had clients who asked me to push the envelope and maybe do things that were unethical. I restrained those impulses. I think you can do the same, working in government, working in private practice. And so we can all recommit to a profession that is going to give to us that ability to master a wonderful profession, right? Skills that can change lives, right? Give us a degree of autonomy where we're not working in, sweat mills, right? And allowing us to recommit because of that flexibility, because giving us a chance to feel like true professionals. If we then commit to the rule of law and things like access to justice, right? We can give back to a community which has given us the opportunity to be, leaders in our community because we are the guardians of democracy and the rule of law. So I think that because we're able to make the practice of law more inclusive, more accessible, because of remote tools, we then can recommit to the things that the legal profession should stand for. So not to get too elegiac, but I'll stop there. Love to get to your questions. I do think that this is a very exciting opportunity. And just like we were able to transform the practice of law in the turn of the 19th to the 20th century, to some extent, right? Allowed us to make it more accessible, to harness technology to serve the community better. We have a long way to go in terms of inclusion, but I do think, the silver lining that you talked about, Professor Mamaysky, is that I do think remote technologies and other technologies we're using today can make the practice of law much more inclusive. So I'll leave it there and kick it back to Professor Ewert, and you can lead us in questions from the group, which from our participants in the audience, because I really want to get to those. Thank you.
Excellent. So thank you so much. So before we open up to questions from the audience, there are two things that I'm hoping that the panel can respond to as we think about, our audience here, who's primarily law students who are embarking on this, new career, a new role. So the first question relates to some of the challenges that we see in terms of the technology gap and access to justice. And Professor Stringfellow, Otey in particular, talked about, some ideas that we could implement to make the courts more responsive or to make our practice method more responsive to vulnerable people. And I'd like the panelists to sort of talk about what can we as practicing attorneys do to effectuate some of those changes. And then the second question that we'll talk about after we have that initial discussion is, okay, given that there has been this sort of cultural revolution around the use of technology and more remote practice, how can these young attorneys talk to their partners at their firms or their supervisors and other organizations about how to establish some of the boundaries that you all are saying are necessary to sort of practice in a way that is healthy and sustainable? So let's talk about what can we as practicing attorneys and these students as soon to be new attorneys do to help effectuate some of the policy or structural changes to make the courts more accessible?
I can start us off. The things that I'm thinking about are, the things that I mentioned that we missed in this rollout. I don't think it was there were any ill intentions. I just think that when you're working quickly, you just do what you know to do. And so one of the things that I'm just thinking a lot about is like, who's in the room when we're making decisions? Whose perspective are we taking? Who are we asking? Because I do that in my own practice. I roll out an idea and here's the workflow for how we're going to do an expungement or whatever. And this study and just this thinking about these last couple of years has made me stop and say, okay, what's the workflow for a client? What is it to receive a communication from me? What does that then make them go do? Where do they, what access do they have? So for me, it's we've got to put on the lens of someone who's unrepresented, someone who's has low socioeconomic status, someone whose language is not, first language is not English, and just sort of reframe the way that we do things. And I think that, the reports I'm reading in the California courts and the New York courts is there is now a movement to do that. But we've got to do it everywhere. And I in my research, I don't always think about rural environments because I don't live anywhere near any. But I'm thinking about what is it to access justice in rural environments as well. So that's the stretch for me. And I think we all have a stretch, where we can say, I just don't think about what it is to be someone else. And so the lens for all of these teams, I think, is the starting point.
Yeah, I would jump off on that. I think sort of 4 things that I would think about. One is to use your market power, that, you should demand, the flexible work arrangements, and the market will sort itself out. And, we had early on in the pandemic, I think it was JP Morgan, I think, said to all the general counsels, they sent out a memo, we're going to insist on all the firms working in person. And like the firms kind of laughed, and that's not happened. So clients are also, clients are using their market power to say, you know what, I don't need to pay for 4 attorneys to travel from New York to LA for a 10-minute status conference. I like that. And, the courts are saying, yeah, you don't need to travel across country for a 10-minute status conference. So you're, as emerging lawyers, you can, go to the places that are going to offer you the more flexible arrangements. And the more the firms see that, and the firms are terrified of that, I'm telling you right now. So use your market power, number 1. Second, once you get in there, show, show the value that you have as understanding the technology better, which you will, than the sort of old guard. For clients, demand that courts are respectful of the arrangements that your clients have. If we're talking about, remote appearances, insist that, you can't go forward in a way that doesn't take into account the needs of your clients. And then I think also sort of show, not tell. When we a couple of years ago with some students, I worked with a legal services office to create a website that would give homeowners facing foreclosure information about the foreclosure process. And lawyers in the community now, it was designed for pro se litigants. Lawyers in the community used it who are taking fees from these homeowners, saying, look, the foreclosure process is quite complicated. You can go to this website rather than have me sit here 2 hours and you pay me for 2 hours to explain the process to you. Go to this website and you'll get a good sense of what the process is like and what I'm doing, and you can educate yourself. So to the extent that you can sort of show the skeptics who are your colleagues that there are efficiencies out there. There are ways that technology can make the practice of law better, more efficient, more affordable for your clients, rather than just telling them, show them. And I think that they'll come along. I don't know, Professor Mamaysky, if you have any other thoughts along those lines.
I would only add sort of one related yet unrelated thought. I love remote work, right? That's obvious from my comments. That said, I think that for new attorneys, there is tremendous value to going into an office most days. And I think that you'll receive a level of training early on in your career and you will make connections with partners and other associates and the rest of the staff of your employers, wherever you end up, that you wouldn't make if those relationships only exist online. Once you've been trained in your field, once you've become established in your career, it's then that I think that sort of these online opportunities really open up new worlds. But I think early in your career, I actually would not advise law students to advocate all that much for, to be able to work from home. Like if you really need to, sure, go for it. But if you have the option to go into an office every day early in your career, I think it's the right decision to make.
So I think I would agree with that, and that go in eyes wide open. What are the policies? What is the flexibility? Just to ask the questions and to go. I would go to a place that allows you the flexibility and understands, are the partners going to be there? Because if you're the only one in the office, you're not going to get that mentorship. You're not going to get that experience. So you got to sort out that culture and try to get a sense of what the culture is like. And when if you ask you're in a room with a partner and a senior associate, and you say, so what are the work from home policies here? And the partner is saying, oh, they're really flexible, they're really great. And the senior associate is like blinking, like, don't believe him or her. Really try and suss out what the culture is. But I agree, being in the office, there's certain real benefits to it.
And then one really quick follow-up to that. So the fact that we do have more conferences online, I think that's going to continue. We have more bar association events online, that's going to continue. How do these new attorneys go about networking and building those relationships, given that remote is here to stay for many of these things that were historically in person? Any tips for that?
So look, remote is here to stay. That's for sure. If your goal is to network and meet people, right, then the best thing to do is attend an in-person CLE, right? Attend an in-person bar event, shake some hands, meet some people, right? Like that. It's the old school way is still the best way to network. That said, if you participate in these types of online conferences, online events, the key is to follow up with the people who speak. So for example, you can find us on LinkedIn, right? Or I don't know who's on LinkedIn here. You can find us on LinkedIn. You can send a message, connect, make it an ongoing conversation, and make it sort of a real relationship that you develop online. It's a better starting point for it to start face-to-face in person. But if it's not, that's also fine. You just have to continue the communication beyond the first meeting. That's the key. But you would have to do that anyway, even if it isn't person.
I think that you can also, flattery gets you a long way, right? And nothing is more important to people than people looking at their work and reading what they've written. And you can reach out to somebody cold and say, I read your article, or I saw your quote in the newspaper. I saw your LinkedIn post, and normally I would try and find out if you were speaking somewhere or if you were going to be at a bar association meeting. But we're not really doing those so much these days. Do you have 20 minutes for a quick Zoom for some advice or for some feedback on something that I'm putting together? People are very generous. They to do your homework. Don't make it clear that you've actually read that article, read that book, whatever it is. But people will respond well to that.
Yeah, seems like there's an invitation to really use the technology that's been developed over the last couple of years, and now with the world kind of opening up a lot in some spaces, but to sort of do a hybrid approach, and which I think is an invitation to discernment. What is a meeting? What is an in-person? What's a Zoom? What would be the best use of time? I think there's, it's sometimes tempting to just say, oh, I don't ever want to drive anywhere again, so I'm going to Zoom everything. And that's probably not a discerning decision. And then trying to be at everything is also, we don't need to anymore. So that's probably not a discerning decision. But just thinking through, what's the best way to connect with people, given that I have two options, and really so much of life is what should I do? What could I do? And sort of working those things through. And the same works with serving clients. I was thinking about when Professor Brescia was talking about, like, it sparked an idea that, like, community education, I don't have to do every bit of community education in person. We can make quick YouTube videos about a few things, use that as a bridge that can be watched on someone's phone, so we can do some interesting things as long as we keep in mind the perspective and the resources of the people that we're reaching.
Fantastic. Okay, so we've got a little bit of time left. We're going to transition now to audience questions. So this is not just a general free-for-all. I'm going to ask that folks raise their hands. And if you're directing your question towards a particular panelist, make that clear. Or if you would like the whole panel to respond, make that clear as well. And it looks like Dean Leisinger has his hand up first. Oh, Dean Leisinger, you're muted.
Sorry, I tried to serve as an example by putting my hand up first. A number of the comments that you made raise an interesting kind of question for me. And a lot of what I do is work with students that want to go out and practice in rural areas here in Kansas, and I've spoken on rural issues nationally. What we have been seeing is attorneys for an access to justice sort of concern, literally serving 3, 4, 5 counties, driving hours back and forth most of the days of their practice. And when COVID came and Zoom came, they're now doing those 10-minute hearings, and they can do them back to back to back and that sort of thing. What I'm also seeing is firms developing a new hybrid firm model where they have a central firm location, and then different associates or attorneys within those firms will go do a single day in a smaller rural community to have that personal connection with those folks, and then do follow-up as Brittany Stringfellow Otey said. They'll do those follow-ups afterwards via Zoom and do those sorts of hearings. Your thoughts on kind of that rural sort of thing, and where that goes, how that works, and the whole concept of the connection between lawyers, clients, and just the changing nature of how folks have access to the legal system.
I think it's spectacular. I think remote court appearances in rural communities, Albany is, the capital of New York State, of course. There's the Tri-City area there, very urban, but for hours in all directions, it's rural. And we have a legal services office that serves, I think, 11 counties, from Dutchess County, which is just, maybe an hour or so north of New York City, to the Canadian border, right? That is a good 5-hour drive. That's their catchment area. And for clients, where there is less, public transportation, clients with mobility impairments, I think that, rural law is probably, stands the chance of being transformed for the better because of remote communication with clients, the sort of telelaw model, and then remote appearances.
I agree. The best ideas that came out of the LA County Courts work study, they were all in the rural areas. And so how do we get broadband access to a community, and what can we do as far as supplying lawyers and access to the courts? I think this is an exploding space as far as access, for sure.
Professor Mamaysky, did you want to jump in, or should I move on to the next question?
We can, I think everything.
Okay, great. So the order I saw the hands go up was Derek Liebly, Jacob Overby, and Emma Stott. So Derek, what would you like to know?
Yeah, my question actually is directed more towards Professor Mamaysky, but anyone feel free to jump in. But I was just wondering if primarily working from home detracted from the ability of attorneys to feel a sense of like collegiality and worker morale towards each other. And if so, if you had any solutions to that. I know you mentioned going to in-person bar events, but like if you're primarily forced to work from home and don't have the option to come in at all, are there like events or any advice you have for that?
Sure. So let me answer this question in a couple of ways. First of all, we talked about the parallel trend of higher education going remote, right? If you were to ask me, Isaac, what's better? Being in a physical classroom with Professor Brescia, right, or taking his class online, right? I would tell you, no question, it's better to be in a physical classroom, right? Like it's better culturally. You're going to meet the other students, make deeper connections, all that stuff. However, when you're out in the professional world, right, years later, and now you have kids and whatever else, and you have life obligations, and you can't just like drop everything and go to class, but you want to, to gain some knowledge from formal education, right? Your next best alternative is to do it online. This is how I feel about remote work in many ways, but let me answer your question directly. In my experience now, I work at a firm where everybody works remotely, right? I have much closer connections with my colleagues at my current firm than I did at the large firm where I started my career, where we all came into the office. Why is that? We have a weekly practice group call, right? It's sometimes it's video on, other times it's video off. We connect every week. We discuss what's going on in the group, what everyone's working on. We're talking constantly. We have in-person events. I mentioned at the start of this thing, I have COVID right now. The reason is we just had a firm retreat, right? And so I went to DC, flew there, the entire firm flew there, and we had a multi-day retreat where we all got together. And what the research shows on, and then I came back with COVID, of course, but it was still a really nice retreat. What the research shows on remote work is that the most effective arrangements for remote work are not fully remote. It's when there are regular in-person opportunities to connect with colleagues, but you also have the flexibility to work from home. And I think that's the ideal combination. So the ideal combination is you find the place where you can still have those ongoing interactions. You still have a team that's committed to forming nice relationships, and there are processes to make it happen. So I hope that answers the question.
Jacob, what would you like to ask our panelists?
So my question is directed mostly at Professor Stringfellow Otey, but I'd like to hear the insights from everyone if they have something to provide. So my question is, and I'm sure a lot of my colleagues will echo these sentiments. Even in law school, I've struggled with work-life balance and maintaining healthy balance of anything, really. And one of the things that you spoke of in practice is setting boundaries. As someone who is a future attorney, going to be a young attorney, going into law firms where we hear horror stories of zero work-life balance and just not being able to set any kind of boundaries, what would you suggest to us as a means to effectively set boundaries without ostracizing ourselves in the firm?
Absolutely. So full disclosure, I never worked in a large firm. That was part of my boundary. so there's that. And I'm not anti-big firm, but that just wasn't for my life. The way that I talk about with my students is that how you do finals is probably how you'll do firm life or just life as a lawyer. That's stress. And I don't know about you, but when I was in law school, I would just call off 3 weeks or whatever, a month, 3 weeks usually. And I would just tell everybody, I'm sorry, I can't get back to you about anything. I can't have any responsibilities. My relationships will have to go dormant. I'm going to eat terribly. I'm going to stay up all hours and be fearful that I haven't memorized enough and just sort of be a mess. And that was very normal. And I looked around, it seemed like that's what everyone was doing. So it seemed great. And in my research, what I've realized is that's the perfect training ground for these things I'm talking about. And I also have come to the conclusion that while I don't exactly know how, and the other panelists would be better at talking about how to negotiate with a large firm for boundaries in your life, I do think that even when you don't think you have wiggle room, there's wiggle room. I recently gave up social media about a year ago. And the amount of time I got back in my life is kind of alarming. And the things that I have, like well, it's kind of funny. I replaced it with high school football stats, which is not the best use, but we're really into our high school football team in our town. I know so much about that I know that I could fill that time with even more valuable things, and I'm going to work on that as soon as football season's over. But even in that small tweak of my life, I found some wiggle room that I would have told you I didn't have. I'm a mother of 4. My husband and I both work full time. We're involved in our community. We have a big, full life. And by a small tweak, I learned all this ridiculous knowledge. So what I would say is I could also learn another, practice area or all sorts of things, or I could have more time with my community. So practicing this, particularly in finals, which I know are coming. And so I would challenge all of us to use that time. What does it look like to make a schedule for myself that includes healthy foods and activity and connection with people that care about me and don't care what grades I get, and the good, long, focused study? That's the practicing that I think is really useful for the future, as I do think there's a bit more wiggle room than we know. But I would love to hear the other panelists about how do you negotiate more boundary than is expected in those firms.
Can I think this is very, very useful insight. I would add one critical piece of things that I think, if you forget everything else I said, the law students on this call, remember this. Choose your practice area wisely, right? Your quality of life will drastically change depending on the practice area you're in. So if you are going into a busy litigation practice where they're doing commercial litigation, you're going to be working 24 hours a day. You're going to have deadlines outside of your control. And you can sort of mandate some level of quality of life, but it's so much of it is outside the hands of even the partners you're working for, because it's driven by aggressive opposing counsel, intentionally sending things on Fridays and whatever else. But there are other practice areas that are completely different. And when I was a law student, the world of practice areas, and I think this is so terrible, right? We understood there to be litigation and transactional work. That's it, right? You go to a firm, you either do litigation or transactional work. There is so much more out there, right? Just as one random example, there's a whole field of education law, right? Working with higher education institutions. There are so many fewer emergencies in a regulatory education practice than there are in a corporate litigation practice, right? So I encourage everyone on this call, if you have questions about this, email me, because I've done a whole lot of thinking about this and a whole lot of advising law students about practice areas. If you choose the right practice area, it will avoid the need to negotiate quality of life. And the one final thing I'll add is never over the course of my legal career have I been as stressed as I was during the finals period in law school, right? So you should appreciate that you are in a uniquely stressful time. And if you choose the right practice area, and once you learn what you're doing and how to practice, your quality of life will get better and better and better with every passing year out of law school. If you choose the wrong practice area in the wrong firm, that won't be the case.
I just love that. Thank you.
Yeah, and I think, we're at this point, right? Sort of about work from home is really live from work, right? Which is not good. And so I think you getting a sense of, the work environment you like to be in, the supervisory relationship you want to have, the mentoring you want to have, the type of work you want to do, the practice area you want to be in. You don't really learn that from the outside. And so I would urge you to, try to do, your internships, really try to figure out some of that stuff. There are a couple of different dials, right? There are a couple of different levels you're gonna be playing with. We've talked a lot about, how much you're gonna have to be in the office, but it's also, what are the hourly expectations? What type of supervisory style is it going to be? Is there a degree of creativity? When do you get to, sort of spread your wings? Is this the kind of place you're going to work where you're not going to be able to be first chair even at a deposition for 5 years? Or like at Legal Aid, where I was doing a trial in like week 2, right? Which was a little scary, mind you, but I liked, that's what I wanted. So, there's a great book out there by Bill Burnett and Dave Evans, which I really can't recommend highly enough. And it's a great read over, winter break, which is Designing Your Work Life, How to Thrive and Change and Find Happiness at Work. There's these 2 professors at Stanford who teach in the design school, and they use this sort of designed thinking approach to careers. And it's really about experiments. See what you like. I supervise students. I recommend students, who take an internship program that I run. And I say, when you're doing an internship, you're assessing the placement. You're being assessed by the placement, obviously, but you're also trying to learn about yourself. What kind of work setting do you want? I worked at an organization in New York City called the Urban Justice Center, and we were very much the type of place where we prided ourselves on saying, we write our job description every day. We don't know what our clients are going to throw at us. Today we'll be working on an environmental justice case. Tomorrow we're going to be working on a workers' rights case. The next day we're going to be doing, an economic development project. And we all thrived that way. Some people didn't. Some people wanted, they wanted to do Social Security disability cases. They wanted to know every case that was out there. They wanted to have read every circuit court decision ever issued on Social Security law. They never wanted to be surprised. They wanted to know exactly what was happening. And that's cool. That's what they wanted. That's not what they were going to get at the Urban Justice Center. So, think, those internships, you're going to be evaluated, but you're evaluating the placement, and you're also trying to figure out what did you like, what didn't you like, what helped you thrive, what was the shortcoming for you. I also, there are little things that you can do. There's a feature on Outlook email where you can delay delivery. If I'm sending an email because it's the right time for me, the pasta's in the pot, I can send a quick email at 7:30 at night. I don't send it to anyone, any student, any staff member, not even a colleague. If it's after 5:30, I delay delivery till the next day, right? So there are little things that you can do. If it's a place where the partner emails you at 11 p.m. and expects a response, don't work there. Just don't work there. But the only way you can really know what the culture is like is by working at that placement. Also, have an outlet. You can't see this really well. I paint Napoleonic era cavalry. That's my little thing. I spend a couple of hours every Sunday afternoon painting toy soldiers. Kind of nuts, right? But it's so relaxing.
Can I just add one? Can I add one final thought on this? I think law students place a lot of pressure on themselves to find exactly the path they need to take coming straight out of law school, right? The thing to keep in mind is that when you leave law school, you don't really know how to practice yet. I mean, this is obvious. You learn how to practice with your first job. You can treat your first job almost as like a postgraduate fellowship in the practice of law, whatever you want to call it, right? Think of it as your graduate degree where you're actually going to learn how to practice. So the first job you take out of law school, maybe it is going to be stressful. Maybe it is going to be crazy hours, right? And maybe that's not the worst thing in the world because you'll learn how to practice. The thing to keep in mind is that your skills are transferable. And once you get out in the world, once you learn how to practice, you can then rely on this concept of lifelong learning. Again, pick up that treatise, read 7 pages a day. You will learn a whole practice area very quickly by doing that. And then you can pivot. Once you actually know how to practice and you know the legal profession, and you can find that practice area that's going to be conducive to the quality of life you want. And it might not be that first job you take out of law school when you have fewer options. But once you've been practicing, you're going to have many options and you're going to know the legal profession well. And then it's a question of exercising your options as opposed to staying on the path you chose out of law school when you were 23 or 25 or whatever age.
I'll also put in a plug for clinics that you can do. You can learn a lot, working under the supervision of excellent clinicians, in addition to internships, as I talked about. But you don't have to wait for that first job out of law school to start exploring these issues.
Well, I always appreciate a plug for clinics, so thank you so much. I didn't even ask him to say that. So I've got three folks in the queue, and I'm hoping we have time to get through all their questions. So I have Emma Stotts, then Nicole Smith, then Gabby Stein. So Emma, what would you like to ask our panelists?
Thank you so much. And thank you everyone for sharing your insights. These are very, very helpful for especially us three. I was about to go into the practice world. So thank you. My question is directed at Professor Brescia. I was curious, you said, so at the end of your discussion, you talked about this recommitment to the rule of law. And I was wondering that if, in your opinion, we as a practice area, as professionals have gotten away from that rule of law, and if the Zoom world has attributed to that.
On the first side, I would say yes, we have. There's this sort of drip, and I don't want to get political here, but if you read some of the emails of the lawyers who were supporting the Stop the Steal campaign, it's outrageous. And across the political spectrum, lawyers are saying it's outrageous to knowingly lie about facts. I mean, that's unethical. In order to overturn an election, it's one thing to say, you may have fudged the facts a little bit to get your client a little more money in a personal injury action. That's bad enough. But to subvert democracy, I'll just leave it there. Read the emails. It's really quite remarkable. I like the second part of your question. I'll have to think about it a little bit, which is, in the Zoom era, has this Zoom life contributed to it? I don't know. I do think that there's probably some softening of the edges in the practice of law that happens by seeing your adversary face to face in court, that you can, I worked on a case years ago under the tutelage of the late Michael Ratner, who was a very progressive lawyer, who worked on, lots of big high profile cases. He led the campaign around Guantanamo, very progressive lawyer. And this was, litigating against the first Bush administration's Department of Justice, against very conservative lawyers, including Ken Starr. And the first thing he would do when we got on the phone with our adversaries, hey, how's it going? How are your kids? And we as law students, we're like, these lawyers, they're the devil. How could you do that? It's like, no, it's all good. Just trust me on this. Well, a year later, when we needed to ask for favors from our adversaries, they were much more willing to give them to us when, Michael treated our adversaries with respect and civility. And I really think we're losing some of that in the Zoom era, that it's much easier to be crass, to be uncivil, when we're all, 1 inch on a screen. So I don't have the research, I don't have the data. That's just my gut saying it. But I do think that we've lost a little bit about, in the practice of that collegiality for sure.
Thank you.
Thank you. Great questions.
Thank you. Nicole, what would you like to ask our panelists?
This question is primarily for Professor Stringfellow OT, but anyone can jump in on it. I love the idea of the mobile court as a solution for lack of accessibility. How do you envision that working? Is this similar to the forms to filing way that we do things like expungement day events, or more of a like park and view kind of thing? And how can we as future attorneys help something like that come to fruition?
Yeah, so I was thinking back, we actually used to have a van that would go to different neighborhoods and do expungement day, things like that. The way I've seen it just in my cursory overview of what LA County was trying to do was actually bringing court hearings to like a community center or, a big screen in order to provide access to the courts when they were closed during COVID. So I think there's, with nonprofits, and I think also just like mandates from the court, I think there's some possibility for new ideas to spring up on how to do it. But I think the way that we're talking about with like in the rural areas, just having a day, a week or something when resources are available. It'll be interesting to figure out how to pay for it. It always is. But I could see legal services making that a larger piece of their programming. And I think I would just start asking questions about whether those things are going to pop up in your area, because I think they're coming, and I think they'll be wanting to bring in attorneys for it. So I don't know a ton about it. That's one of the things I'm really interested to see what will happen. But I know like even on a dime, they were able to implement that during 20 and 21. So I think it might be here to stay.
I'm going to exercise some moderator privilege and jump in here.
Yeah.
So those of you who know me know that I spent part of my legal services career in homeless services in Baltimore pre-pandemic. And what was really awesome was the growing movement around the country to link legal service to other services. And so we would have, either things where there would be, community events where there would be lawyers on site to help with legal needs, but also mobile dentist vans, mobile showers. So folks experiencing homelessness would be able to go and have an actual shower, be able to have their teeth cleaned. The DMV would often come out and bring their mobile, cameras so people could get their ID cards, their state IDs and stuff. And so this actually has been going on for a little while, but sort of like, a one-off event, maybe, once a year or twice a year. And so I think what Professor Stringfellow Otey is talking about and what other people are envisioning is having this be a more ongoing, regular thing. And so there's definitely an appetite there. And there are, models in place for how you can do this. The question is then just, how do you get it more frequent and the funding? But there are a lot of, philanthropic organizations, different charitable organizations, and also private firms who see this as part of their larger, pro bono commitment, who are willing to help support some of this and even send attorneys out to help at some of these events. And so there are models around the country for having this, done effectively. So really, really exciting. So thank you, Professor Stringfellow Otey, for raising that as an option. Gabby, what you're probably going to be our last question here. What would you like to ask of our panelists?
So this question is in response to Professor Stringfellow Otey's presentation. You touched on something that I think all of us experienced, that technology helped bridge the forced physical distance during COVID, but that it just can't compensate for that sense of interpersonal connection that's formed when we have an in-person conversation. So how did this impact how your clients felt about their outcomes in the justice system? Did you notice a shift in how your clients felt about their outcomes with remote hearings and proceedings and such?
I'm still kind of thinking that through and talking about that a lot with my students who have had the experience. We found it was really hard to build that initial rapport and trust. It just felt different than any other time that we've represented clients. They did appreciate not having to come meet us. So I am really sold on as if you can, doing an initial in-person to build a bit of a connection and then utilize that and work off of that and then use the technology to make life easier for people. So it's a kind of again, I'm always coming back to the hybrid, right? But the thing that I am noticing and thinking a lot about is I think we had more people sort of I call it, they kind of float away. They come in really, really in need of something, and then we can't get a hold of them in the future. And sometimes it's because life has become complicated and they just can't focus on the legal matter that they came to speak to us about. But I wonder, and I lean toward thinking that the connection, the personal connection wasn't as strong that would then help them to keep coming back. So we did have more drop off, but we also had more complicated lives. So I don't exactly know, but I have attributed some of that to just, we couldn't make that bond. We couldn't connect over a sports team, or just, especially, in our situation, there's such a socioeconomic divide between our students and our clients generally. And so compassion and empathy and in your eyes, that we rely on that in order to convince our clients that we care. And so I think without that piece, we were handicapped in some ways. So I do love the idea, and we're implementing it now, taking some, learnings from the past year. Let's try to always connect in person if we can, and then absolutely do the phone next time so that they don't have to take time off of work, things like that.
Thank you. Elizabeth, did you have a quick last question? I saw your hand go up there.
I did. I kind of, as a way to wrap things up, I think throughout all the presentations today, kind of one of the major things that we've come back to is that we shouldn't be online because we miss out on kind of that human connection, and that there's a lot of value in that, and building rapport and building trust with clients. Maybe each panelist could say, what's one reason or multiple reasons why we should do more things online. If you could deduce it down to one reason.
Well, I don't mean to beat the drum, but I do love not asking my client to get on a 3-hour bus ride. I do love not asking my client to miss a day of work if they are working. I do love not asking them to find someone to watch their children, or drag them into a legal clinic. Yeah, that's just not how I want them to. So I love giving them some freedom. And so I am committed, and we are working, using, tech all the time to free them up to do what we can after we've made a connection.
I think the thing to keep in mind is that with our profession shift sort of to online communication, something is gained and something is also lost. But think of how much is gained, right? Like when you're leaving law school, before you have little kids at home and professional obligations and all this stuff, it doesn't matter. Go in person, meet people face to face, right? Years later, when there are kids at home and constraints in your time and all this stuff, getting on a train for some meeting that's an hour away is just terrible, right? This symposium is a great example. Here we are talking online, right? The alternative would have been, and I was willing to do this, right? Because this is an exciting discussion. I was excited to take part in it, but the original plan for this symposium was me hopping on a plane, right? Leaving my kids and everyone at home and figuring out childcare, going to you guys so we can speak in person. Now, would the conversation have been a little more engaged if we were in person? Probably, right? Would I have also spent multiple days of my life like on a plane and away from my kids? Absolutely. So it's like something is gained and something is lost when we speak this way online. But I'll tell you, depending on what phase of life you're in, a whole lot might be gained. And my experience working at a virtual firm is that the relationships really can be very, very strong when you predominantly communicate online.
And Professor Brescia, would you like to wrap us up here?
I'll try. I think that I think it's a question of balance, and we have to align, the format of our communication, to go back to McLuhan, right? Like the medium is the message. The format of the communication should fit what you want to get out of it. And, there's no doubt in my mind. I mean, I know I experienced it that, brainstorming with people in person, over pizza and, soda, late into the night with a whiteboard, like there's no substitute for that. But, sometimes it works. A lot of times it's not great, right? Can you get 90% of the benefits of that from other means of communication? Or can you be intentional, right? I don't think you must be intentional about what's the mode of communication, when is it going to happen, how is it going to happen, with whom is it going to happen? The idea of the sort of serendipitous, you bump into somebody in the hallway and it launches a unicorn company because you had some brilliant news flash because you just happened to bump into each other on the way to the bathroom. It's just not how, it's not how the force works, to borrow a line from Han Solo, right? Like, that's not how it works. Sometimes you get a flash of inspiration. Check when you had the last inspiration. Was it walking your dog? Was it on a run? Was it, in the shower? Chances are those were solo activities, right? I think that there's a time and place for certain activities, to get, the benefits of them. And we just have to be intentional when we're going to do that. When is it appropriate? I think Professor Stringfellow, Otey said it before, like, when can it be an email? When does it have to be a meeting? When should it be a Zoom? Like, let's think about it. Like, let's, and the days of the partner saying, I need to have all of my associates within 10 feet of me at whatever time because I might be inspired to have someone go research a footnote. Well, shoot an email,
Well, thank you so much to all of our panelists for spending the morning with us. We certainly learned a lot from you and feel like the law professors and experienced attorneys could also benefit from the tips you gave us.